There's nothing more powerful than the odor of mendacity.
Sir, Mr. Copeland, is it your desire to release your counsel at this point in time?
She fired.
She's fired? Okay. So do you wish to represent yourself in these particular, in terms of any issues you may have in this particular?
Do I got a choice?
I'm sorry?
Do I got a choice?
Yes, you do.
And what are those?
You can keep your lawyer that you have right now.
I don't want her.
All right. You could certainly hire another lawyer, or the court could appoint you a lawyer.
What I need a lawyer for?
It's just the court is just asking you whether it's your choice, sir.
I'm good.
You're not doing that at this point in time, so you'll have a choice to make. All right, take Mr. Steele into custody, please.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of situation?
Okay, all right.
May I say one thing, Your Honor?
Yes, sir, you certainly may. Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people. I've denied your motion, but I'll certainly take that under advisement, sir. We're going to be in recess for...
And welcome back inside the law. My goodness, what a day, what a week, what a month. I mean, this entire Young Thug trial is something else to behold. I didn't really realize, yesterday when things really went off the rails, when Brian Steele, as you saw in that clip, got arrested or held in contempt, and the judge was about to cart him off to jail. I had no idea what was going to unravel. And I know you didn't either, but we're here today to try to break down some of what's happened today. And there's been a lot. The first clip that you saw was, of course, let's just call him the reluctant witness, Mr. Copeland, whose meeting yesterday, along with the prosecutor and his attorney, meeting with the judge in the judge's office in secret. We call that an ex parte discussion. It's not allowed under almost all circumstances, not allowed. But that meeting involving that witness set off this entire bizarre chain of events. And we're going to try our best to understand what happened and to break down some of the more recent developments from today. But before I do that, I want to just revisit, if we can, a longer version of what happened leading up to Brian Steele's arrest. Okay, so let's go ahead and check in with this.
Going forward, what I was told was that Mr. Copeland said,
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this. I have problems right now.
All right, you see, the judge is more interested. He's less interested in the problem that the judge caused by having this ex parte proceeding one-sided without the defense lawyers even knowing about it. He's less concerned with his role in causing all this than he is finding out how it got out, I guess, beyond the four walls of his office, which that's a problem. He seems to be just clueless about his role in causing all this. We'll talk more about that.
Okay, I know. Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that somehow you have surreptitiously gotten information in regards to the court's private.
He's concerned that he surreptitiously got his information about the judge's surreptitious meeting. All right.
Ex parte conversation with a party. I mean,
A witness who was sworn in Friday. The court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it
or
proprietary?
Information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said.
Did you catch that? He started to say this honorable court, but then he said, let me rephrase that, this court.
That I can hold you until the end of this trial. Ms. Hilton supposedly said actually all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why,
sir? I'm going to hold you in contempt if you don't tell me who tell me who this information was.
I don't want to be held in contempt.
Well,
I'm
then,
not answering that question. That's attorney-client privilege information. I am not
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I am telling
I tell you what, I'm going to give you 5 minutes. If you don't tell me, if you don't tell me who it is, I'm going to put you. I'm going to put you in contempt because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did
you know, it seems to me that if you walk in and you just flip off a judge, you know, that would be contempt. You know, that's the kind of thing. What I'm looking at here, I'm not looking at contemptuous behavior, in my opinion. I'm looking at advocacy. You've got a lawyer who's making an objection, a valid one, by the way, to the judge having a secret, I guess not off the record, but sort of behind closed doors meeting with the prosecuting attorney and her witness, who is already under oath and has begun his testimony. And they're in the back discussing the sanctions the judge is going to impose if he doesn't cooperate. That's what I'm hearing. And if that's going on, that's a valid objection. The judge is not letting the attorney complete a sentence to perfect his valid objection. But now what I see also is I see some emotions getting involved. And anytime that happens, things are bound to go sideways.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, you know, I don't need it. I want to continue.
You got 5 minutes.
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
So I guess he admitted to killing someone in chambers. I can't wait to learn more about that. And was the deputy sheriff actually trying to take the lawyer's notes right off the podium? All right. So the way things ended up yesterday, I'll summarize it as best I can. At the end of the day, at 5 o'clock, a whole bunch of lawyers from the Georgia Association of Criminal Defense Lawyers, they have a strike force that deals with this issue. It's there to render assistance and legal aid to attorneys who find themselves in situations just like this. And so our friend Ashley Merchant, who's the president of the Georgia Association of Criminal Defense Lawyers, she shows up along with attorney Alex Susor, and they had a hearing of sorts. We live streamed it yesterday, and if you missed that, I encourage you to go back and watch that, because you're really going to be fascinated to see this fiasco of a hearing that took place, because really the judge had he had like an arraignment hearing on this contempt, and then he moved right into a trial. He's jumping all over the place, and then he went ahead and pronounced sentence without even having a trial. More on that later. But at the end of the day, the lawyers for Mr. Steele, Ashley Merchant and Alex Susor, the judge took a 5-minute recess after he heard arguments, and the 5-minute recess turned into about an hour and a half. And then the judge came back out on the bench, and he changed his tune a little bit. He said he's not going to have to go into custody right now, but he's going to have to serve it was a 20-day sentence, which is the maximum you can get for criminal contempt in Georgia. It's a misdemeanor crime, by the way. And he said you can serve it all on weekends. Okay. And so he doesn't have to report to jail until this Friday. So the way that it ended up yesterday gave rise to this right here. This is, let me get to the top of the page. We have an emergency motion for supersedious bond on criminal contempt. Now, supersedious means you're asking the Court of Appeals to essentially intervene, and it's kind of like it puts a stop to the trial court's order. Okay, it was filed today in the Court of Appeals, state of Georgia. You got the movement, you got Brian Steele, and it makes reference to the legal basis for which the emergency motion for bond is filed. It points out some of the factual background, Mr. Steele being lead counsel of record for Jeffrey Williams in the state of Georgia versus Jeffrey Williams, who is young thug, along with the other defendants. And it's a 65-count racketeering 65-count racketeering indictment charging 28 individuals. And it says the trial is expected to last through the end of the 2024 calendar year. I think that's being very generous. I think it's going to go longer than that, or maybe it's about to end prematurely. But anyway, they go on to say that yesterday, June 10th, the trial judge, along with state prosecutors, engaged in an ex parte, that's a one-sided hearing with a sworn witness, Kenneth Copeland. He's the one that she's fired. She's fired. I don't want her as a lawyer anymore. He's the one that fired his lawyer today. And for the sworn witness for whom an order of immunity from state prosecution had been issued. And you may remember one of the problems in the beginning of Mr. Copeland's testimony is that he did not want to testify because the grant of immunity did not cover any potential federal charges. And quite frankly, I don't blame him, because apparently he had a lot to talk about. And if he was obligated to tell the whole truth in open court, he just might confess to a federal crime. So he wanted a more thorough and complete grant of immunity. But nevertheless, Judge Glanville, who likes to use contempt power, as we've now seen, threw him in jail and made him sit there for the weekend until yesterday morning. He says, I'm going to hold you in jail until you comply with the subpoena, even though your grant of immunity is not broad enough. And by the way, I think that Copeland's lawyers, if he hadn't fired him, really should have had a decent appeal, because I don't know how you can force someone to testify if they don't have thorough and complete immunity. All right, but that's neither here nor there. There's lots of side trails we can go down. They point out that no notice of an ex parte meeting involving the state and the sworn testifying witness was provided to any attorneys for any of the defendants in the case. The witness had been previously called to testify on Friday, asserted his Fifth Amendment privilege, and was held in contempt, summarily incarcerated, as we just discussed. Judge Glanville and the prosecutors admitted in open court that an ex parte meeting occurred on the morning of June 10th. And that's one thing. See, that nobody is denying this. And that's what is really so wrong here, is that the genesis of this issue, the very beginning, is a wrongful starting place. This is, for reasons that we'll talk about, I believe, violates the canons of judicial conduct. judges are not supposed to have these kind of secret meetings with only one of the parties and not all of the parties. When the trial reconvened on June 10th, 2024, Mr. Steele informed the court that he and others had learned, based on information and belief, that an ex parte meeting, this is the video that we just played. He had learned that an ex parte meeting with the sworn witness occurred earlier this day. Mr. Steele proffered his understanding that the witness had made factual admissions to criminal conduct, which the state intended to use against Mr. Steele's client, and that the statements were made to the witness about the amount of time he could be held in custody on the contempt. And see, this is the big problem. Steele is complaining about the judge threatening this witness, and clearly it affects his client's interests here. After the court acknowledged and admitted the fact that the meeting had occurred, Mr. Steele demanded information regarding the meeting, and I don't blame him. You got to know, you just can't have judges essentially taking testimony behind closed doors like this. Mr. Steele demanded information regarding the meeting, including the names of everyone who was present. These are witnesses to the conversation. I think it's entirely reasonable to know who was there. He requested a transcript of the proceedings, and he also made a motion for mistrial. There's been so many motions for mistrial, I can't even count. But this one was on the grounds that an improper ex parte hearing was conducted. Now, here, I don't know how well you can see this on your screen, but they drop a footnote here, and footnote number 3 refers to the Uniform Superior Court Rules 4.1 and the Georgia Code of Judicial Conduct governing ex parte communications. The Uniform Superior Court Rule generally prohibits these ex parte communications, except as authorized by law or rule. Judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. They are only authorized in the case of extraordinary matters such as temporary restraining orders and temporary injunctions. In other judicial proceedings, both parties should be notified of the hearing with an opportunity for attending and voicing any objection that may be properly registered. And they cite some case law here from Georgia appellate courts. And then, and we talked about this yesterday, Georgia's Code of Judicial Conduct number 2.9 says judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or impending matter. Now, there are some exceptions, but I have been through every one of these and none of them apply. Some of the exceptions, for example, administrative matters like scheduling and emergencies that do not deal with substantive matters. None of the exceptions, and they're very, very limited, none of the exceptions cover what happened in this case. So in my opinion, in my legal opinion, this ex parte communication was clearly prohibited by the rules of judicial ethics, the canons of judicial conduct in the state of Georgia. They go on to say in this emergency motion for bond that the trial court rejected Mr. Steele's substantive request for information about the ex parte meeting, and they denied Mr. Steele's motion for a mistrial. However, the court instead demanded to know how Mr. Steele came into possession of the information about the ex parte meeting. The judge, in my opinion, seemed a little bit obsessed, a little emotional, a little obsessed, kind of Captain Queegish. Anyway, this filing goes on to point out that Mr. Steele declined to answer the judge for a couple of reasons. I mean, the judge essentially accused him of a crime of eavesdropping, and so he's got a Fifth Amendment right to remain silent right out of the gate. We know that. It says a lawyer shall maintain in confidence all information gained in their professional relationship with the client. And so this is dealing with like attorney-client privilege or attorney work product. This is not necessarily things that the client tells the lawyer, but it's things that the lawyer learns. And by the way, there's nothing that would that should prevent anybody who was part of this meeting in chambers. Nothing would have authorized the judge to swear them to secrecy either. And there's nothing to prevent anybody that was back there from talking about it. Okay, so they go on to point out that the court repeatedly demanded that Mr. Steele reveal the source of information, claiming that the way Mr. Steele obtained the information was unlawful, and baselessly accused Mr. Steele on the record of potentially acquiring information through eavesdropping. That's a crime in Georgia. In response to the accusations and the demands of the court, he relied on the ethical mandates that we just went over, as well as his Fifth Amendment right to remain silent when accused of a crime, and he declined to answer the judge. The court then held Steele in criminal contempt for refusal to provide the source of the information regarding the ex parte meeting, and the court ordered that Mr. Steele be taken into custody until such time as he revealed the source of the information. I want to pause right there and tell you something about how there's something called civil contempt. And the best example that I can come up with is like if somebody doesn't pay child support, you're ordered to pay child support, or you're ordered to pay spousal support, or in the case of somebody we've talked about before in a Cobb County divorce, if you're ordered to pay for your soon-to-be former spouse's medical procedures and you don't do it, you can be cited for civil contempt, and the judge can throw you in jail until you comply with your civil obligations. Now, this is different from criminal contempt. Criminal contempt in Georgia is a crime, as the name implies. You have the right to be put on notice of what you're accused of. That's substantive due process, procedural due process. You have the right to have a trial, and you have a right to have that trial before a different judge, because for a couple of reasons. The judge who threw the book at you that wants you in contempt, that judge is a witness. So you can't be a witness and the judge in the same trial. And it's a conflict of interest because that judge is presumably now biased against you because they would want you to be convicted. So there's some practical reasons here, but the judge seems to not have understood, in my opinion, the differences between civil contempt and criminal contempt. They go on here in chapter 9, paragraph 9. They, as I mentioned a few minutes ago, at the end of the day, they took up the issue of contempt, demanded that Steele reveal from whom he learned the ex parte meeting, and reiterated that he was holding him in criminal contempt, even though he said, if you just answer my question, I'll let you out. He's describing civil contempt. The judge said that, and see, when we talk, he said he could purge himself of the contempt by informing the court where he obtained the information. The phrase purge in the context of contempt implies, and well, it more than implies, it shows that he was confusing civil and criminal contempt, because when you're thrown in jail for not paying child support, the judge will write in the order the purge amount that you have to pay to get out. It may not be the entire amount that you owe, but it's enough to kind of get you going with making your payments. It's called how you purge yourself of a civil contempt. We say in the law that someone in civil contempt literally holds the keys to the jail cell in their pocket because they can purge themselves of contempt by complying with the order. Steele informed the court that the members of the Georgia Association of Criminal Defense Lawyers, and in the interest of full disclosure, I being one of them myself, I am a member of that organization, but several were outside the courtroom. I heard it was upwards of 60 that were seeking to represent Mr. Steele. The undersigned counsel, attorneys Merchant and Susor, were ultimately permitted to enter to represent Mr. Steele, but only after the court had already recommenced further discussion of the contempt issue with Mr. Steele without his legal representation beside him. Following argument on the issue of contempt, the judge issued a written order and an order for incarceration, finding him in direct criminal contempt, imposing a sentence of incarceration for the maximum of 20 days. So a few minutes ago, a few minutes ago, earlier in the day, the judge was talking about you can get yourself out of jail if you just answer the question. But now it's like, okay, well, I'm sentencing you to the definitive term of 20 days. So now the judge has figured out that he can't do it that way. So he's instead of backing down and doing what I think would have been the right thing to do and just admitting that he was wrong and apologizing profusely, he doubled down and he throws him in jail for the maximum that he can, which is 20 days. So when this whole thing started, Mr. Steele could simply just tell him where he heard it, and he wouldn't even have to go to jail, where he could be out in 5 minutes. But now it's morphed into 20 days. So the judge is doubling or tripling down. He said he began to order his service at 7 p.m. this Friday, which necessitates this emergency motion. The appeal that will follow addresses 3 issues. First, did the court abuse its authority in presiding over the very contempt hearing that was born of the allegations? And second, whether the court denied Mr. Steele's due process rights during the conduct of the hearing. And third, whether the court abused its authority in holding Steele in contempt for failing to divulge the information. First, they say that the court had a duty to recuse himself from presiding over the contempt proceeding. I like this word here. I can't pronounce it very well. It says, in such proceedings where the announcement of punishment is delayed and where the contumacious conduct was directed towards the judge, or where the judge reacted to the contumacious conduct in such a manner as to become involved in the controversy, the judge may give the attorney notice of specific charges, but the hearing, including the attorney's opportunity to be heard, must be conducted by another judge. See, we've got this whole body of law out here dealing with contempt for lawyers, because there's a difference between zealous advocacy and being contemptuous for the judge, right? So the judge, look, I mean, do you think Judge Glanville had become involved in this? I think he had. I think he had clearly become an involved party by this point. It says here, the court involved itself in these proceedings by conducting the ex parte hearing that violated Mr. Steele's rights in the first place. This created the conflict of interest. Because the conflict of interest for the court, listen to this, because its own ethical conduct was at the heart of Mr. Steele's request. Bingo, right there. The court's own ethical conduct was at the heart of Mr. Steele's request. The court should have recused and allowed the contempt proceedings to be held by a separate court. As to the second issue, the court denied Steele his due process rights because he was not given notice to be, he was given no advance notice of the criminal contempt citation. He had no opportunity for a meaningful hearing or to call witnesses or to be represented by counsel for the entirety of the criminal contempt proceeding. The third issue, it says an attorney may be held in contempt for statements made during courtroom proceedings only after the court has found that the attorney's statements and other conduct actually interfered or posed an imminent threat of interfering with the administration of justice, and that the attorney knew or should have known that that's what would happen. Because contempt is a crime, the evidence must support these findings beyond a reasonable doubt. Here, obviously, the trial was able to go on. It resumed the same day. So there's no way that his conduct interfered with the administration of justice. And that's kind of what they start talking about. Courts must be judicious in their approach to adjudicating contempt, precisely because vigorous advocacy is essential not only to the preservation of individual rights, but also to the integrity of the judicial system. Trial judges must be on guard against confusing offenses to their sensibilities with obstruction to the administration of justice. Let's listen to that again. Judges must be on guard against confusing offenses to their sensibilities with obstruction to the administration of justice. That means just making the judge mad is not enough. Offending the judge's sensibilities is not enough. It's got to be an obstruction to the administration of justice. So just because you piss off the judge, that's not enough. Steele's statements and conduct did not interfere with or pose imminent threat, because as they point out here that, the court was able to continue the trial after its initial oral pronouncement holding Steele in contempt. His refusal to disclose the name of the individual or individuals who informed him of the ex parte meeting, which he argued would constitute a direct violation of his own ethical duty of confidentiality, in no way delayed or impacted the underlying trial. The court orally ruled that it would not grant a bond. Okay. So wherefore, Mr. Steele files this emergency motion for bond and asks the court order a supersedious bond be granted pending the appeal of this contempt finding and that the imposition of the sentence be stayed. So this is not the kind of bond that you would normally have to post. This is more of a stay of the order of incarceration. The lawyers who signed this are Brian Steele's wife, Colette Resnick Steele, who's a fantastic lawyer in her own right, and his law partner. And then, of course, Ashley Merchant and Alex Susor. They attach as Exhibit A the order of contempt and incarceration for Brian Steele. And they also attach as Exhibit B the notice of appeal filed yesterday by Colette Resnick Steele. All right. So there you have it. That's the emergency motion for bond. And now, before my voice gets too tired, let me stop and acknowledge the 6,713 people that are in here watching live. Welcome to Inside the Law. This is the channel, the LawTube channel, where we take you inside the real justice system, not the one that you might think that we have from watching TV or the movies, but we bring you the good and the bad, and sometimes even the ugliness that we sometimes see in the real life. All right. We've got more that we're going to get into. I've got more video clips and other things. And at the end, stick around when we finish with the young thug craziness from today. We've got some breaking news on the Fani Willis disqualification appeal front. And we'll talk a little bit about that. But before we go, I want to introduce someone to you. Those of you who are in the live chat might be familiar with Kiana Shaw. She's one of the moderators, and she's been keeping law and order in the chat this evening and doing a great job. And she's also been following the events of the trial today very closely. Kiana, thank you for helping out with the chat. What do you think is going on with this trial? What were your observations from today?
Is that no matter how crazy you think this trial has been before, it can always get crazier. The morning opening up with the plot twist of Woody firing his attorney, did not have that on my 2024 bingo card for the YSL trial. And one of the more interesting things that happened was that the district attorney and the defense attorneys were okay with Woody firing his attorney, but the judge was not. The judge tried everything he could to get that woman to stay on, Miss Bumpkus, I think her name is. I'm sorry that I'm probably mispronouncing her name, but he just refused. He was telling her she had to go through all kinds of things, and in the end, he actually gave her a court citation. She has to come back to court June 15th to show cause for why she wants to remove herself as Woody's lawyer, even though he fired her in open court.
All right, now that you mentioned that, I want to show this. And I'm going to ask you, do me a favor, if you can stop your camera, keep your microphone on. I'm going to show a copy of this order. Okay, you still got your mic on? There you go. All right, here's the show cause order. This is the order to show cause. And what it does, folks, is this is new. This is how a court is supposed to institute a contempt, right? You issue this order. This is basically the notice. Okay, this is putting you on notice that you have to show up for a hearing to show cause why you should not be held in contempt. This is part of the notice that was missing from the Brian Steele. But what Judge Glanville has done is he has doubled down and he's ordered all of the people who were present in his chamber. So that would have been, I guess, counsel for the witness, the prosecuting attorney. I think there may have been a sheriff's deputy or two in there for security. And I know there was at least one court reporter, and I don't know who all else was in there, but that's a lot of people that are covered by this order to show cause why they should not be held in contempt. He's trying his best, guys, to find out how Brian Steele found out what was said in that, I think, unlawful ex parte proceeding. So we'll go ahead and you turn your camera back on, and then we'll go ahead and finish talking about this. So the judge just seems to be so laser focused on finding out who spilled the beans, more so than understanding why what he did was wrong.
Yeah, and that leads the fact that he gave her a show cause motion here, whatever it is, he issued her a paper. I say citation just because that's the thing I think of normally. The reason everybody thinks now that he believes, whether it's true or not, that she is the mole, because he just like everybody else. The district attorney was like, or ADA was like, hey, yeah, he's been cured of the contempt. He's done what he's supposed to do. We're okay with her leaving. The defense attorneys were up like, yeah, he can leave. I mean, she can leave. We're totally okay with that. The judge was like, you cannot. You have to file something with me, and we have to file something with the court. And once you do that, he has 10 days to decide. He is actively testifying, and he needs counsel. And Woody's basically over there going, I don't want her.
For those of you who may not have been in here, before we introduce everyone to my colleague, attorney Sarah Hobson, who's going to weigh in on some of this, let's take a look real quick on this part where, for those of you who weren't here and maybe in the very beginning, this is what happened when the witness tried to fire his lawyer, who, by the way, it's my understanding she was filling in because the regular attorney had to go out of town, something along those lines, and she was just there to kind of fill in during his testimony, and now she's caught up in this whole thing. And by the way, if she was the one that talked to Brian Steele, there's nothing wrong with that. There's nothing wrong with it. And by the way, if a lawyer believes that another lawyer, which would include a judge, has violated the rules of ethics, they have an obligation to basically tell on him. So there's nothing wrong with this lawyer spilling the beans. But anyway, here's where he tried to fire counsel.
Sir, Mr. Copeland, is it your desire to release your counsel at this point in time?
She fired.
She's fired? Okay. So do you wish to represent yourself in these particular, in terms of any issues you may have in this particular?
Do I got a choice?
I'm sorry?
Do I got a choice?
Yes, you do.
And what are those?
You can keep your lawyer that you have right now.
I don't want her.
All right.
All right, so that seems to me to be a little bit disingenuous of Judge Glanville, in my opinion, because look, he's saying that he doesn't want a lawyer. And look, what is the lawyer going to do? Tell him to invoke his Fifth Amendment rights, which is going to get him thrown in jail again? The judge is not giving the lawyer any room to work here, because other than just standing there like and doing a potted plant imitation, there's nothing for the attorney to do unless it's to help your client, the witness, take the fifth. And the judge has already said he's going to throw him in jail for that.
And she obviously didn't want to be there. Everything about her posture, everything about what she said, what she did, she didn't want to be there. She did her job as a felon. She told the judge, she was like, I was supposed to be here to ensure that his contempt was purged. And once that was done, I was removing myself. And he told her, no, you're not. And finally, he did allow her to do it. He broke for lunch and allowed Woody and her to have a little conversation. She ended up drawing up the papers she needed to do to withdraw. Woody signed them. They brought them into court. The judge handed it to Woody and said, did you sign this? He said, yes. I think actually before that, he asked him, was he still intending on relieving his lawyer? And he said, yes. And then she gave him the papers and he asked if he signed them. He said, yeah, I did sign this. And he told her, okay, you can be relieved, which is what they wanted to do. They started late, about an hour late this morning. So at about, we'll say 10:30
an hour
morning,
late. Were they having another secret meeting for an hour this morning?
Have no idea, but they still started about an hour late. That's part of the course for this. There are actually people in chats who put clocks on how long the comfort breaks are actually going to be and how long we're going to break for lunch, and how they do over and unders on when the court is actually going to start based on the time that the judge is given. But at 10:30 this morning, this could have all been over. But Judge Glanville, as he did with the steel contempt, as he did when Ashley Merchant came, having people in court basically to nearly 8 o'clock last night, he drew it out. And he eventually did dismiss her, told her she could go because he had in open court fired her and all the little papers were signed, but told her, I'm also giving you an appearance, a summons, you must come back. I can't remember the courtroom number, he said, and we're basically gonna have it out. I think that he's going to berate her to admit that she was the mole personally. That's kind of the way the chat's been leaning. Like he believes, whether she is or not, he believes she's the mole, and he is going to get a little retribution.
All right. So Kiana's telling us that the betting pool has the attorney as being the leak. But again, even if that's true, there's nothing at all wrong with that, in my opinion. It's perfectly fine. All right. Well, thanks for coming in and spending a few minutes with us.
You're welcome. Thank you, guys.
We'll let you go back into preserving law and order in the chat, and we'll pop in anytime you like.
All right. Thanks.
All right. There's and by the way, there's 6,600 people. Please feel free to hit the like button, folks. That's how the algorithm helps other people who might be interested in the legal system finding out what the real justice system is like. It helps them find this channel. All right. I want to go ahead and reintroduce you to a friend and colleague of mine, attorney Sarah Hobson, who I see is waiting patiently backstage and has been listening. And welcome to Inside the Law, Sarah. How are you today?
And what a day. What a day.
I know. And I know that, like Kiana, you've been watching this all day, and you've been practicing law in the metro Atlanta area yourself. Have you ever seen anything like this trial?
Like this trial. I have seen an issue. I actually accidentally discovered an issue of ex parte years ago, in which Ashley also came in, swooped in with her cape and helped me in that instance. But that was not done in open court on nationally televised news. So this has been.
No, and I remember that case involving a now former judge. But you yourself, or basically what you're saying is that you experienced a situation where you had a judge threatening you, or did the judge actually find you in contempt, or what was the situation?
It really just takes us to another level. I was not threatened with contempt or anything of that sort. I just happened to discover, incidentally, an ex parte conversation going on between a judge and two prosecutors involving multiple cases. And here, this is just I can't compare it to anything I've ever seen.
So you uncovered something that you thought was unethical, and Ashley had to kind of get involved to help you solve that issue.
Exactly.
Yeah.
And these issues, as are you. It really, she is the perfect force to represent Brian Steele, and it's just been a really mind-blowing day.
All right, what do you make of this? What do you make of this this whole thing with this new show cause order? It's like the judge the ink's not even dry on the one involving Brian Steele, and he's now threatening to hold everyone else around the courtroom, I guess, including prosecutors, in contempt if somebody doesn't fess up. And by the way, do all of those people, do they need lawyers? I mean, I don't know that the GACDL strike force is going to be able to come to the aid of a prosecutor or a sheriff's deputy or a court reporter. But if this lawyer needs assistance, presumably they'll be there for her as well.
Really, when I read that order, I was so shocked because it was basically a confession and really, in my opinion, a letter of resignation for that judge. I mean, he admitted there's no denying the ex parte occurred. It clearly was substantive because he doesn't want anyone to know what was said. He's very, very upset and angry that the existence and the substance was shared with the defense attorneys. So it was really a bombshell, really, to read that show cause order.
Yeah, let's see here. I want to add to the stage here. Whoop, that's the wrong one. I'm going to get into this in a few minutes. This is where we're possibly headed with later on in the show. We're going to get into the Fani Willis appeal. But here, this is it. So here is my post earlier on this issue. I said the judge issues a show cause contempt hearing for everyone who was present for his allegedly illegal secret ex parte meeting with Fani Willis's top prosecutor. I point out, in my opinion, that he is obsessed with finding the leak, which, by the way, was perfectly legal. So assuming that this attorney is the leak, I think it's perfectly legal, but it seems to me that she's at risk of going to the Fulton County Jail herself.
Yeah.
So,
Needs representation. And in this instance, now that, she's withdrawn from whatever representation she had as a stand-in attorney for Mr. Copeland, he is going to need representation. And presumably all of the court's representatives and the prosecutors.
Look, I don't know that Copeland is afraid of going back to jail. He seems to be. I mean, he's, according to all reports, he spent a lot of time in jail. But I don't think Mr. Copeland was the one that spilled the beans. This order says all personnel, all individuals that were present for the ex parte conversation. And the reason I'm making this larger, this show cause order in this document, the judge he's confessing that he held this ex parte conversation and that it took place in his chambers on the morning of June 10th. Everything that was alleged in the emergency motion for bond that I just went over, the judge he literally just glosses over the fact that this is wrong. This ex parte conversation should never have taken place. He fails to even acknowledge that. But instead he just goes straight for ordering all these people to show cause why they should not be held in contempt for disclosing information from the ex parte conversation to members of the defense counsel, who, by the way, were entitled to know about it. I just can't. The circular reasoning here is just stunning, Sarah.
It leaves my volume. I might have to switch over to my phone, but yeah, absolutely. And I think what's interesting too is, upon information and belief, this wasn't the only ex parte conversation. If you listen to the audio and the video from Friday evening, when at the tail end of the hearing, right before court went into recess, you can hear Prosecutor Love notify the judge that the state had an ex parte matter that they needed to take up with the court. And I don't know that a lot of people caught that. So upon information and belief, there was an ex parte conversation Friday. And
there was another one Friday. And so maybe Friday they were getting ready maybe they were planning to have their ex parte on Monday.
Party planning. Yeah, that's what it sounds like. Okay. So it's really incredible that he's admitting to it. He's referencing the word ex parte repeatedly in this order. He's referencing it repeatedly in open court on the record. It's a dirty word for a judge to be associated with. It's just it's like a 4-letter bad word, and he's just referencing it repeatedly. I did want to mention, there were some people saying, well, could there be any situation where it would be appropriate, other than what you've covered in this, under the statute and under the rules, perhaps if there was witness intimidation, would that be appropriate for a judge and a prosecutor to meet with a witness ex parte? And I would posit that no, that's not, particularly with something like that. A defendant has a right to be present and to hear those allegations and defend themselves against those allegations. If there's any witness intimidation or coercion, you might be able to speak more onto that. But there's not. Even when an attorney contacts a judge ex parte about a scheduling issue, it is always still required to let it be known to the other party. Even on scheduling issues, we have a right to have our have knowledge of what was discussed and to have our input.
Yeah, that's a good point that you make. This really is a sort of a dirty word in the law. It's the kind of thing that you don't want to get caught engaging in, and yet he seems to have no problem acknowledging it. I pointed out here in this Twitter post that, in my opinion, Glanville should immediately step aside from this case and retire. And I don't say that lightly, because I don't think he's going to like the blowback that's probably going to eventually land on him. Because look, this is the kind of thing that the Judicial Qualifications Commission is going to get involved with. I've got it on pretty good authority that may have already been filed with that state agency, and they have the power to investigate and to discipline judges, and they can even recommend their removal from the bench. Now, they recommend it to the Supreme Court, which has to decide. But a lot of judges, rather than go through that, once the Judicial Qualification Commission sinks their teeth into a judge, most of the time they go ahead and just give up. They will just go ahead and retire, resign. And he's been on the bench a long time. I'm sure he's able to retire. He may have military retirement as well. I know he was a general in the Army or the Army Reserves and served on active duty and served with distinction, I understand. So I think that if he was smart, I think he would stop digging his heels in. I think he would go ahead and acknowledge that he's gone a little too far here, and try to see if another judge can finish out this trial, if it's even possible to salvage the trial. And I don't think it is. But, and I want to get your opinion on that. But to me, I think this is, if we haven't seen anything that's reversible error yet, I think we've seen it now. What do you think?
So, you and I both know in our experience in case law, when the more a judge fights a recusal, the more it is evidence that they need to be recused, that they somehow have some personal or vested interest in the outcome of this case. And every defendant is entitled to a fair and impartial judge to hear the facts of this case. The more he fights it, the more evidence he's giving to the defense team to show, if he sticks with this myself or allow another judge to hear a recusal motion, he's just providing all the evidence. And it's really interesting that not only did he have Monday night to sleep on it, 4 hours in between holding Mr. Steele in contempt and Ashley Merchant showing up and him doubling down again, and then he slept on it. And then at the end of today's hearing, he then provides a show cause order to Ms. Bumpus. It's like you can almost understand a little bit making that mistake as a judge if in the heat of the moment you're really angry and you're going to require that this attorney be held in contempt, and you bring him to your holding cell, and then you have 4 hours at least to cool down, to think about it. Maybe call one of your judge friends. Maybe call the JQC for advice. Maybe call the bar for advice. The hotline. We as attorneys, we can call the bar and get advice on ethical or moral issues, and also to sleep on it and then just double down again.
There's a question here that's posed in the chat, and I wanted to just kind of reference it. Once there's an allegation like this of corruption, or let's just call it, I don't know that I'm not Judge Glanville. I wouldn't say corrupt is the right word, but I think he's gone too far. I think he's stepped over the line with regard to these canons here. But once this allegation is made, I think that the JQC can take action, but it kind of moves slow. What I think you're going to see first is you're going to see, I think probably as early as tomorrow, if I had to bet, we're going to see the Court of Appeals grant a bond to Brian Steele, so he doesn't have to go to jail this weekend first, and that will stop everything. And then the appeal starts taking place on this issue of contempt, and that can take a little while. But it's not like the appeal of a trial, because there's not much of a record here that they have to prepare. But the appeal could still take several months, and it may hold off until after the trial is even over. But I think the first action that you're going to see is them granting a bond to Brian Steele.
Yeah, that needs to happen. I mean, I'm even hoping that perhaps Judge Glanville will awaken to his conduct, and it's not Friday evening yet. It's not Saturday morning yet. No, I don't think that there is a chance. But that again is just further evidence of, why are you so vested in finding out who leaked this information? If it wasn't a big deal.
All right, here's our colleague Richard Lawson. Thanks for the super chat, Rich. Much appreciated. It appears that Glanville took advantage of a young attorney. He and the assistant DA intimidated her client into testifying. And by the way, I don't know Ms. Bumpus. I don't know anything about her experience or her age or anything like that. But I think Rich makes a very good point that what does appear to be going on is some intimidation here. And let's face it, a judge, particularly the chief judge and perhaps the biggest judicial circuit in the state, that can be an intimidating proposition when you got a judge staring down at you, threatening you. I mean, that can be intimidating, particularly for a young lawyer. But you notice Brian Steele, he wasn't intimidated. He stood his ground heroically, I might add. Rich says that now the judge is going after her. She has a right to remain silent since she's facing criminal contempt. And that's exactly right. And so I think that she will show up at that show cause hearing unless it gets canceled. And she will have representation with her, and she should, because none of these people are in a good place. Looks like Sarah might be switching out her audio equipment. So I want to go ahead and address some other questions. Let's see what we got here. Is there any way Brian Steele can get a mistrial without asking the judge? Well, no, you've got to request it. I mean, the judge theoretically can grant their own mistrial. They can do it on their own motion, but that's not going to happen. But we have seen lots of other attorneys in this case also asking for a mistrial. And for example, let me show you this clip right here.
Contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
All right. So
and frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
Well, I asked him, so I didn't ask you.
Yeah.
So, but I'll leave it at that. Okay.
Yeah, the judge knew better than to ask him because they're all going to give him the same answers. And so one of the points that was made yesterday by some of the other defense counsel regarding that transcript, they're saying, look, we've got to prepare tonight to cross-examine this witness. So we want you to release the transcript so that we can find out what was said so that we can, adequately cross-examine this guy. And the judge stubbornly said, no, he's not. He said, if the Court of Appeals wants it, something like they can have it. But anyway, we've just gone so far into the surreal now. It's crazy. I've been watching this chat, by the way, over here, and the folks in the chat are Sarah, you're muted. I don't know if you knew that, but the folks in the chat are doing a great job. And I've been watching these comments, and you guys are really, really impressive. There's some excellent comments, excellent questions. By the way, if you agree with anything, I want to hear it. If you disagree feel free to say that too. I'll go back and I'll watch these after the fact on the replay, and I'll check out the live chat because there's a lot of things that I miss. And I'm very interested in what you got to say and weigh in on any of this because it helps me figure out what we're doing right, what we might need to do better next time. And by the way, thanks to everybody. There's 7,000 people in here now. Hit the like button. That'll help others find this channel. And thank you for supporting Inside the Law. There's links provided in the show description. If you like this content, feel free to help support so that we can continue to provide new and additional better content. Sarah, I don't know if you're muted. I don't know if I'm trying to unmute you, but I can't. There you go.
I have a, let me see. Sorry, give me 1 second.
Well,
I've got I think I have to join with my phone for the audio. Can you hear me right now?
Yeah, can hear you fine. Yep.
And
all right. So
on the audio backstage, but I think I need to be joined on that so I can mute myself on my computer.
All right, let's go ahead and I'll remove you for now and give me the thumbs up when you're ready. You're still in the green room. So looks like the judge participated in coercing or intimidating a witness. And see, that's exactly part of the problem. That's why they need the transcript, because we don't want to have to guess at what happened in there. We want to know what exactly the judge did and why. Maybe there's a good reason for this, but I doubt it. I can't find any of the exceptions to this rule that would apply to permit an ex parte under these circumstances. Let's see, another question here. Thoughts on what George Chetty said yesterday about the security coming and talking to him and the content of that conversation. So George's his idea, his hypothesis was that maybe the judge was taking up some security concerns because the witness might be a target for assassination or something along those lines. And even if there are security concerns about a witness, it's not the kind of thing that you got to have in private, because if you're talking about the substance of the case, which is what they apparently were talking about, that's clearly improper. I don't think that even if you have security concerns about the witness's safety, that's not a basis for an ex parte conversation either. But a great question. Let's see. This is another excellent point. Is there anybody in this trial that doesn't have everybody's got a lawyer? It's surreal. Even the lawyers have lawyers now. All right. So is there any way Brian Steele can get, we've already answered that question. Sorry about that. Is it possible that the ex parte conversation was a security issue with the witness? That's the one I just went over. I don't think that that's the case. And even if it was, it doesn't give rise to an excuse for this ex parte. Shree points out, thank you for the super chat. Wanted to say she's happy to see with 34,000 subscribers, and now enjoy the rest of your evening. Thank you so much for the comment and for the super chat. And yes, we are approaching 35,000. That's my next goal. So if you haven't subscribed, please do so. And if you know anybody else that wants a place to come learn about the real justice system, suggest this channel. This is just one of the many places where we take you inside the real justice system, not the one that you may think we have. This live chat, though, you guys are just absolutely on fire. I'm loving seeing this. Sarah, give me the thumbs up. You think you're good? All right.
I think I'm good. I'm good.
All right. So you were watching everything today, Sarah. Tell me what you think. I'm trying to find something while you answer this question. I'm going to try to find something I posted on Twitter earlier and share it. What do you think today was the most significant, and what did you find most interesting about today?
I found it interesting that yet again, there is a clip where Ms. Bumpus asked the court if she can approach the bench because there's something that she wants to discuss with the court, but not in open court and not on the record. And Ms. Bumpus and the prosecutors approached the bench for a little sidebar. The jurors are not in the courtroom at this time. And you can see on the clip that the defense attorneys start walking towards the judge's bench to be.
So wait a minute, they're trying to have another ex parte right out here.
Again.
I mean, by the way, guys, ex parte doesn't necessarily mean behind closed doors. It can be right there out in the open. If you're having a sidebar, but you don't include all the lawyers, that's also ex parte.
Correct. I can be whispering something in the judge's ear, or, it's just it's Latin for one side only. And so the defense attorneys are approaching the bench, and Judge Glanville says, and I'm going to read it so I don't misstate. I don't believe you have a right to be up here to the defense attorneys. And it's literally the same people that were involved, minus Mr. Copeland, in the ex parte that occurred on Monday morning. Again, trying to have an ex parte right at the judge's bench. And it just makes you wonder why are they so comfortable doing this? Like that they're completely oblivious to having their name associated with the words ex parte. I cannot stand, I cannot tolerate, I don't ever want to be accused of or be associated with having an ex parte conversation with a judge. It is dirty, it is wrong, it is unethical, and they're just flippantly doing it right in court with cameras on. What happens when there's not cameras on?
I know. I mean, and this is, it's almost like they're just so comfortable with it. I found this Frank Sullivan's comment. The judge has obliterated his career, which dovetails into to this thread that I posted here. Let's make it a little bit larger. See, I posted that I have it on good authority that Glanville can expect a formal complaint filed with the JQC in the very near future. And I think I posted that yesterday. So maybe it's already been filed. I don't know, but I would be shocked if it hasn't, or that it won't be, very, very soon. I point out here again, the subject to that complaint, improper ex parte, in this case with the DA. This is serious. And this is our thread from yesterday. And we pointed out that, as the rules we were talking about, the rules say that clearly you can't, these ex parte things are just not tolerated. And there was some case law that someone brought to my attention. And this is, I thought was interesting, where there's no immediate punishment for contempt. A defendant in a criminal contempt proceeding, and this is one where they're not immediately throwing them in jail, right? If it's something that's so bad that they just immediately throw you in jail, that's not what we had here. A defendant in a criminal contempt proceeding should be given a public trial before a judge other than the one reviled by the contemnor. So this is old school 1971 language, but basically it points out it should be given a public trial before a different judge. And it also cites, that's from the United States Supreme Court, by the way, from a Pennsylvania case, and also one from Georgia. So the fact that the judge did not even see fit to remove himself, from the issue and let another judge basically take over, shows that the judge seems to have some kind of interest or bias in the case. Your thoughts before we move on to the Fani Willis disqualification appeal?
Yeah, absolutely. I mean, I think he's just shown day after day that he's vested in this. And I get it. It's been a very long trial. To lose it now would probably be very disheartening for him to, have to grant a mistrial after all the expense and effort and human capital that's gone into this prosecution. But that does not change the responsibilities of the judge to be fair and impartial. It doesn't change the law regarding ex parte conversations and due process, even for attorneys when they are charged with contempt. So it's just really mind-boggling. I was hoping things would turn around today, and it just seemed to just go deeper and deeper. And that seems to be a theme with Fulton County.
I'm going to get into, in just a minute, I'm going to get into the news on the Fani Willis thing, but I want to my point and what you were just saying about the judge essentially seeming to have his emotions sort of involved in this, and he's a little bit, maybe too invested in it. This is from late last week, but this I think makes the point. Take a look.
And I know that they did know that he was going to take the fifth, because I heard it said outside right before I walked into court. I even said, the officer.
Then why didn't you, as an officer of the court, tell me before we took his testimony?
I told Mr. Steele.
No. Why didn't you, as an officer of this court, tell me?
Well, then that's my.
I got a problem with you now.
Well, that's fine. I mean.
I got a problem with you now.
Well.
I would suggest you don't say any more.
I've already said it.
I know that, sir. And the problem is, you should have told me. If that were your case, then you've just made an argument we didn't even need to have, because I could have certainly asked him based upon your proffer. Now you want to have it both ways. You can't do that.
Your Honor, I thought the state knew that. And
that's not what the point is. The point is, you as an advocate, is you should have told me.
Both sides have an equal responsibility under the rules of professional responsibility.
Okay, as long as we're both responsible, that's fine.
All right.
Well, now he's interested in the rules of professional Look, I mean, can you see how he's not even letting people finish their sentences? He's not letting lawyers make their point. He's literally, he's getting very animated. It's almost like he's very quick tempered, and it's the kind of thing that I don't know. I mean, is this what you should go to? Should you go to judicial anger management to be able to control your temper?
Phil, I think
I'm being serious, actually. I mean, it's almost like he just doesn't have the judicial temperament necessary to conduct these kind of cases.
And I believe the remedy is it's time to start a new career. If you don't have a judicial temperament to speak professionally to attorneys with decades of experience, I have to say what I'm so proud of though is that this case is really shining a light on the Georgia criminal defense bar. And I am so proud of all of these attorneys. I mean, even the attorney in the clip that you just showed, I've got a problem. Well, that's fine. He just took it on the chin. He didn't get emotional. He didn't mirror the judge's anger or emotions. He was professional. And I mean, I'm just so proud of these attorneys, with all the lawyer jokes out there. Look at the Georgia criminal defense bar and how they are handling these Fulton County trials. And I mean, they really need to be commended.
So Larry,
really proud.
So Larry makes the point, can there be an accelerated, or the question, can there be accelerated appeal to the Court of Appeals? So we talked a little while ago, I talked about this emergency motion or for a bond, and it's pretty fleshy. It's got a lot of substance to it, and you're going to see some kind of order from the Court of Appeals. And the way, when they basically, probably by tomorrow or the next day, there'll be an order, I predict, in place granting bond. That will be a signal to the judge, hey, wait a minute, you need to, hold your horses here on this just a little bit. But that's the way to do it, is the way that they have done it. You guys are asking awesome questions. Keep it going in the chat. Talk about this, talk about anything you want. Talk about me if you want. Talk about each other, but be nice. But I want to switch gears, okay? There's something else that's going on in the news related to the Fani Willis appeal. Okay. So this is my tweet from, I guess, earlier today or yesterday. The judge has said he will continue to work on the Trump Georgia case during the Fani Willis appeal, despite being ordered by the Court of Appeals, despite there being a stay. I pointed out that, in my opinion, this is extremely foolish. He says he's only going to work on defendants who did not participate in that appeal. But I believe that if he takes up any matters with regard to any of the co-defendants, there's a really good chance that it could impact the other defendants, because when you have all these defendants tied together in this indictment, the saying is a rising tide lifts all boats. And by the same token, the lowering tide lowers all boats. And so they're all sort of chained together, if you will. And so there's that issue, but there's also another issue where let's say that Fani Willis is in fact removed from the case. Any work that he does goes out the window. Anything that he does, because she's the one her office anyway is the one that's having to deal with any other such matters. So I don't understand really what the judge is thinking here, but what he says he's going to do, Sarah, is he says he's going to work on only those defendants who were not part of the appeal. So let's take a look at this guy right here. Those, you can see there's only just a handful of them that are that participate. And I don't know, to this day, I don't know why every defendant in that case did not join Ashley Merchant's motion, because all they had to do is adopt the motion, and next thing you know, they're just they're on the train, and they're along for this ride. But all of these defendants, the Court of Appeals says these proceedings shall be stayed and it lists those defendants who are actually part of the appeal. The judge takes the position, and I do not agree with him, by the way. I don't think he can do it, but he's taken the position that he can carry on with work related to any other co-defendants. What do you think, Sarah, is behind this?
I don't know. I mean, it just, I mean, I'll tell you the far theory, does he think for some reason that the Court of Appeals is going to rule in the state's favor and might as well just keep chopping away at this? It seems that it would be a major waste of taxpayer dollars to continue to do that with such a strong appeal pending before the Court of Appeals right now. I don't understand the logic, but then again, I haven't understood the logic behind a lot of what's been going on in the Fani Willis Trump trial. So it's kind of par for the course.
Well, look, I mean, if think about how much there is to, and this is already costing the county and the citizens of the state of Georgia, and particularly Fulton County, a fortune. And the last thing that I would want to do, particularly if I'm a new judge and I've just recently secured election to my own 4-year term, like he did last month. I mean, he's basically saying, look, I'm going to go ahead and plow forward. And look, Sarah, I think there's a really good chance. I mean, look at I did a live stream about just on the members of the Court of Appeals, the judges who are going to be addressing this issue. And based on that, based on also the fact that they did the stay, I think that the odds are really, really good that they're going to, at a minimum, toss Willis from this case.
Mm-hmm.
I'm
Yeah,
really getting that. I'm getting that vibe. And so if he presses forward and continues to do work related to these other co-defendants, and then they rule that she's disqualified, all that goes out the window.
Mm-hmm.
It's just a waste of time.
It is. It's almost like, the house is on fire, but let's continue with the kitchen remodel. What are you doing that for?
Yeah, exactly.
What are you doing?
And look, I mean, I'm not attributing any ill motives to the man. I think he's conscientiously trying to work through his caseload. And look, Fulton Superior Court judges are, if they're nothing, they are in love with their scheduling orders. They like to keep plowing forward. It's just kind of what they're known for. But sometimes there's a really good reason to stop. And I think this is it. When the handwriting on the wall says that Willis might very well be about to get tossed off this case, it's not going to hurt you to move on to some other cases for a while, because you can't try this case anyway. You can't do anything until, at least with the main defendants, if you will, you can't do anything until the Court of Appeals rules. And then whoever loses that is going to further appeal. So there's going to be more appeals than that. So move on, try some murder cases, try some people that are in jail that have been waiting 3 or 4 or 5 years in the Fulton County bedbug infested jail, and move their cases along through the system. That's just my thoughts.
There's thousands of cases to move. There's thousands.
All right. Well, speaking of thousands, I got 6,000 folks in here now. Please hit that like button. I appreciate every one of you being here live. And for those of you who watch on the replay, I appreciate you as well. The chat is just moving faster than I can keep up with, guys. And I'm going to go back and watch this. I think it's great. I love to watch this conversation. Sarah, we're going to go ahead and say goodnight to Sarah. Everyone, big round of applause for Sarah for coming in and sharing some of her time and her expertise with us here inside the law.
Thank you for having me.
You bet. We will catch you next time. And you guys here, don't forget that this is the place where we're going to try to tell you the truth about the real justice system. So if you haven't subscribed, please consider doing so. Please consider sharing this channel with anybody that you know that might have an intellectual curiosity in the law. We look at the law in the context of real cases that are in the news. And by the way, we haven't even talked today about the Hunter Biden guilty verdict in the federal court. We'll do that maybe another day, but we have plenty of things to talk about that are high profile cases or cases that are in the news, but it's not always things involving Fani Willis. It's not always things involving Donald Trump or Hunter Biden. Look, we've got the Idaho murders. We got that case coming up. There's bound to be some things we can learn by breaking that trial down. We've got Lake and Riley coming up here in Georgia. Lots of other cases that we are going to be using as a mechanism, a vehicle, if you will, to take you to inside the real justice system. So, thank you all very much. I really appreciate each and every one of you. Thank you so much for being here and hanging out with us. And, before you go, don't be this guy.
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all now. I ain't gonna tell you no lie.
Yes, you may. We're gonna take a break. Hang in there.
That's a real state's witness in the real trial, Young Thug trial. This was a witness. You talk about being in contempt of court. If I was a judge, I would have thrown him in jail for that, because, you can't come to court and not be sober and giving testimony for the state that's designed to incarcerate people when you're in that shape. That is contempt of court. What you saw going on this week with Brian Steele, that is advocacy. That's good lawyering. That's not contempt of court. And I predict that very soon the Court of Appeals is going to agree with me. And look, whatever happens in this case, we're gonna be here. We'll cover it. We'll talk about it, whatever it is. But it's not looking good for the viability of this Young Thug trial. Lots of very serious issues, allegations of judicial misconduct, and lots more to explore. So we'll see you back here next time inside the law. I'm sure this is not the end of it, but thanks so much, everybody. I really appreciate it, and we'll catch you next time.